And then agree
On Mr. Boyd?
on board. Yes, ma'am.
Okay. Is it
It's a
a,
rejection.
okay. Good morning, sir. Are you David Alexander Boyd?
Yes, ma'am.
And Mr. Boyd, in cause number 25, DCCR 0720, you're charged with the third-degree felony offense of deadly conduct, discharging a firearm from March 20th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I'm going to get
A,
a plea bargain rejection. What is the offer?
The state's offering 10 years, probated for 10 years with a $2,500 fine, standard conditions and no contact with a couple of complainants, as well as stay away from the Little Woodrow's establishment.
Sir,
There.
spit whatever is in your mouth out in that trash can over there. So you've signed a plea bargain rejection with your attorney, Mr. Jeffries, and it's going to show 10 over 10, right?
That's right, Judge.
So it's for, if you wanted to enter a plea of guilty for a 10-year term in prison, that would be probated. You'd be on probation for 10 years. You would be ordered to pay a $2,500 fine to follow all of the rules and conditions of probation. You have every right to reject that and have your case set for trial. I want to make sure you understand today what your options are if you wanted to plead guilty and what your possible consequences are if you go to trial and are found guilty. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get it set for trial. Mr. Coleman, is there any reason to believe that that offer would change?
Not at all, Judge.
So, Mr. Boyd, I want to make sure you understand that after today, I don't accept plea agreements once they're rejected. So unless new information comes to light with your attorney or the district attorney's office, then if you change your mind later and want to enter a plea of guilty, it would be to something different than this or open to the court. Do you understand?
Yes, ma'am.
All right, then we'll get your case set for trial and Mr. Jeffries will begin preparation. And if y'all will just send that through, I'll
Just see.
sign off on it. Okay, perfect. You're free to go, sir.
Thank you, ma'am.
Larry Fletcher. Good morning. You're Larry Fletcher?
Yes, ma'am.
And Mr. Fletcher has 3 cases. He has a motion to revoke his probation, and then 2 new cases, cause numbers 25 DCCR 0839, a manslaughter case, and 25 DCCR 0838, an assault, aggravated assault with a deadly weapon. And what is the, so there was we were here at one point, and he entered pleas of not true in the motion to revoke probation. And it was, I guess, kind of reset for sentencing, but with those new cases, what?
Your Honor, with the court's permission, the state would like to proceed on the MTRP first.
Judge Matt, if we're going to do that, I'd ask the court for 2 weeks. To do
No,
that.
we're not doing that today. I mean, because
No, okay, I'm sorry.
no,
I'm not
inclined. So, okay, here's the thing. Typically, the way I'll handle motion to revoke in new cases, if the new cases are, I don't want to have to hear it all twice. So if it's a new case and it's a witness or 2, that's one thing, especially if it's a lesser offense. With these types of offenses, would typically be more inclined to hold the motion while we take care of the other cases.
The state's thinking, Judge, is depending on the outcome of the MTRP, I think that would be dispositive, potentially, of the other cases, without the necessity of having to pick a jury and go through the jury trial. But that's just the state's preference, too.
Right.
I understand the court's decision.
No, and I'm not saying I'm opposed to it. I'm trying to, so this underlying offense that he's on probation for is a second-degree felony. So what would it would be proving up the aggravated assault and the criminally negligent homicide?
That's part of it, yes, ma'am.
Time frame on that type of hearing?
Would be extensive, Judge. No more than a day. No more than a day. That's probably at the high end.
Okay. All right, so he's already entered the pleas of not true. So I'm going to kind of grant what Mr. Coleman is requesting on this one.
If it's essentially, and I'm not complaining about it, Mr. Coleman has the right to do whatever he wants here, but if it's essentially going to be miniature trials, then I would ask the court for some time.
Sure. No, so what I'm going to do is reset it for sentencing. Obviously, I need to find a day. Probably going to be 45 to 60 days out. Obviously, I know that might be quick to get ready for a trial, but I think you should already have
We're working through the discovery. Yes.
Is there anything you're waiting on? Anything that's pending, outstanding?
Yeah, I'm not aware of it, but he's saying no, so then.
So because we're going to do it this way, let's do about 60 days, and then we'll look and find a day on a week where we do not have a trial, and I'll give you guys at least a day on those weeks. We can even have a little bit more. All right? Okay, we'll see you back.
And there it is, a quiet moment in a crowded courtroom, where choices harden into consequences. In minutes, futures are weighed, freedom on one side, uncertainty on the other, a rejected deal, a trial ahead, and the heavy truth that every decision carries a cost. Justice doesn't rush. It waits, patiently, for truth to be tested under pressure. There are no rewind buttons here, only forward motion. As the doors close for today, one question lingers in the air. When your moment comes, will you face it, or gamble everything on what comes next?